Hi, this is John Goodman, and we are talking about holdover rights today, specifically the holdover rights that a listing broker might have after the expiration of a listing agreement. So, the first question is, what the heck are holdover rights? The holdover rights are essentially this notion that the broker, while the broker had the listing, might have been part of procuring a buyer for the transaction, and that conveys value for the seller. And the seller shouldn't be able to scheme and wait out the expiration of the listing period and then put a deal together with that buyer. If they do, the broker should get paid for that transaction. So the concept of holdover rights is that the listing broker has commission rights. The seller has commission obligations to the listing broker for certain kinds of buyers that close after the listing period expires. All right, so we're asked a fair amount of questions about holdover rights. One of those questions comes from a succeeding broker. So the scenario is there's broker number one who lists it for the seller for a certain term, let's say 5 months. After that term expires, then there's listing broker number two. And the question is, does the seller have obligations to pay listing broker number one if the seller relists with broker number two? And it depends. It depends on how the holdover rights read. In Colorado, we are fairly clear on this. There is a section in the Colorado Real Estate Commission approved contract that has a will or will not box. At the time I'm recording this, this is in section 7.3 of the state approved form. If the will not box is applied, and that means the holdover rights do not apply for the benefit of the prior listing broker if the seller relists with a new listing broker. Of course, if the will box is checked, then the holdover rights do apply and benefit the prior listing broker, burden the seller, even if the seller relists with a new broker. Another question that comes up, what happens, John, if the old listing brokerage agreement doesn't expire, but it's terminated, it ends in some fashion between the seller and the old listing broker? There's a falling out. Well, if the listing agreement is expired through paperwork that says the expiration date is moved from some date out in the future and is moved earlier to the date of the end, then that means that the holdover rights would still continue to apply. Contrast that with an amendment to the old listing agreement that says it's dead, it's terminated. Then it's not perfectly clear, but it's fairly clear that if there's a consensual termination of the agreement, if words like death or termination or rescinded or void are used, getting rid of the old listing agreement, then nothing survives the old listing agreement unless the terms explicitly say otherwise. Ladies and gentlemen, another third question I'll end with. The third question is, so John, my listing agreement is ending. I'm the broker who is losing out. We don't know what the seller is going to do. What happens if I send an information dump? You know, suppose I list everybody in the phone book, every buyer in the phone book. If you don't know what a phone book is, ask somebody over 35 years old. I send the phone book to my seller. Does that mean I lock in my commission rights for all those buyers? And the answer generally is no. For example, in the Colorado form, in order for a buyer to count as a holdover buyer, it's not just that the buyer's name needs to be identified to the listing broker. It's that the buyer's name needs to be identified and that buyer be somebody who the broker negotiated with. Ladies and gentlemen, as always, remember, I'm just a lawyer in Colorado. It's hard enough for me to keep track of the law in Colorado, let alone the law of other states. This is not intended to be legal advice for anyone, but if you're out of the state of Colorado, it's especially important you talk to a lawyer in your own state. And remember, we live in a complicated world. Be careful out there.